Today, Outside the Lines.
In the violent world of the NFL, the question of medical care and benefits for retired players is a long-standing, often emotional question. For years, under a generous California workers' compensation law, any pro athlete in any sport who has ever played in California could file for cash benefits for injury suffered during a career, regardless of where the injury occurred. Now a pending bill in Sacramento would cut off this pipeline of cash, which retired players call essential, and leagues, clubs, and now many legislators consider an outrageous loophole. This is larger than football and professional sports, touching all industries. But retired NFL players are the most visible subjects of this politically and emotionally charged topic. Today, Outside the Lines, a needed medical benefit or cashing in on a bad law.
And now, reporting for Outside the Lines, Bob Lee.
You might not believe some of what you're about to hear today about the workers' compensation benefit that's been available to any workers, such as a pro athlete who ever worked a day in the state of California. It might seem the equivalent of a retired athlete finding a winning lottery ticket in his sock drawer, except players will tell you this is deadly serious. This involves their health, and they need all the assistance they can get when they've played professional football and live with the impact of that for years. All of this is coming to a head right now for thousands of athletes, many of them retired NFL players, right now in Sacramento, California. In a huge state coping with skyrocketing taxes and municipal bankruptcies, this issue is easily cast by politicians and the NFL as rich athletes racing to cash in on a lucrative loophole in a generous if ill-conceived state law. The players counter that not only do they pay income tax even as visiting players in California, the insurance in question is not funded by taxpayers but by the football clubs. Still, California's liberal interpretation of workers' comp rights has led to such well-advertised cases as a $199,000 California settlement to Terrell Davis of the Denver Broncos and nearly $250,000 to Michael Irvin of the Dallas Cowboys. A player needed only to be on a team's roster while the team played in the state of California to be eligible to submit a claim for a cash award. The league says some players are double dipping, collecting from two states, and some who are 60 years removed from the playing field have filed claims. The union maintains players have no recourse because the clock runs out in most states to file a claim, while football-related health complaints lie dormant for years. The current bill would restrict claims for cumulative trauma from out-of-state athletes to those employed in California for 90 days out of the last year. It would also bar other claims from players unless their final season is with a California team. Unless cemented, the bill would erase all pending claims, even those nearing resolution. Well, the California State Assembly passed this bill recently overwhelmingly, 61-4. It is now awaiting action in the California State Senate. A vote could possibly take place on the floor there within 1 month. Just a moment, you'll hear from both sides of this issue, including a player from 2 Super Bowls who said he's been left now with huge personal and uninsured medical bills from his playing career. But first, a conversation with ESPN.com senior investigative writer Lester Munson to sketch some of the outlines here on the story. Lester, you've been reporting the story. This is bigger than sports, this particular bill that's on the table in California. And it's bigger than just the National Football League. It involves all industries. But workmen's compensation is a huge matter for the National Football League. Why so and how so?
Workers' compensation provides that anybody who is injured at work must have their medical and hospital bills paid by the employer. In this case, the owner of the NFL team. Workers' compensation is one of those great public policy breakthroughs in the United States. It's there with Medicare and Social Security. It's a system that is supposed to take care of workers who, while on the job and doing their job, are injured. Football players have always had difficulty collecting on workers' compensation. Some states are very stingy with the players, such as Indiana and Tennessee. California is the state of liberal benefits, as you have described, Bob.
And, of course, as far as California is concerned with the National Football League, it is not just this law which is an issue because of the matter of money and the number of people involved, but there are a number of different fronts where this is being contended right now.
There are indeed. The owners of the teams and the league are fighting the players on three fronts. They're fighting them in state court, they're fighting them in federal court, and as you described, they are fighting them in the legislature. The owners of the teams are clearly tired of paying workers' compensation benefits. They have never wanted to pay these benefits, even though all employers in the remainder of the U.S. economy must pay them. And now this is an all-out war that we have going on in California.
All right, Lester, stand by. Let's now hear from both sides on this issue. When we asked the National Football League for a representative on today's panel, they suggested we invite attorney Bob Corker. We're certainly happy that Bob is joining us today from Cincinnati. Andrew Brandt, ESPN NFL business analyst, joins us, as well as Reggie Williams, 14 years in the National Football League with the Cincinnati Bengals, served the city council there in that city, and with both his knees now with severe and chronic problems 24 years after his last National Football League game. And it's good to have you all here. Bob Corker, what do you make of this law? And I know you represent leagues in their actions on workman comp issues, and the characterization of the reporting from Lester that this has been a struggle, if not a downright denial, to pay rights and pay benefits.
Well, first let me say it's not just a football issue, Bob. This issue has captured the attention of the National Basketball Association, Major League Baseball, the National Hockey League, and of course the NFL as well. In fact, while the focus from the player side has been on the football issues, as we sit here today, there are more claims being filed today by baseball players than the football players themselves. So it's indeed been a gold rush to California, excuse me, to file for workers' comp benefits that frankly isn't happening anywhere else in the country.
Reggie, is this a gold rush?
No, I think it's more like a scar rush. The only reason that I am before you is because of the cumulative trauma that I've suffered from playing 14 years faithfully for one employer, the Cincinnati Bengals. This is not about holding California taxpayers accountable for the injuries of players throughout the National Football League or other leagues. This is about holding your previous employer accountable for the injuries you occurred playing to win a Super Bowl for them. And in this case, all it is about the Cincinnati Bengals appropriately being responsible to take care of the long-term cumulative damage that I suffered playing on the hardest AstroTurf Riverfront Stadium for 14 years.
But Reggie,
so the very premise of
I was going to say, there is an appearance issue here, at the very least, the way at least it's being presented by proponents of this bill. Again, this bill wants to, in their words, close the loophole. And that until recently, in fact, this might actually also be in dispute, we can even drill down on this, to simply pay or play one game in the state of California or exhibit that some of your cumulative trauma happened there, even in a minute amount, enables you to go into California and file a claim. You will admit that on its surface, a lot of people, their jaws are going to hit the floor when they realize that.
That is not the focus of players who are hurt now. Players who played in the 70s and 80s when the game was much less regulated, where the rules actually contributed to injuries. Head slaps were legal, hitting high and hitting low were legal, clipping was legal, horse collar tackles were legal, clotheslining was legal, playing on horrible fields with less than adequate equipment. So you have to put it in context of poor player salaries during the 70s and 80s compared to the salaries now. Now, getting back to the abuses, this is about the whole system of holding teams accountable. This is about trying to preserve a system of justice, going before a judge who can make that determination, Bob. Don't eliminate the players who live the American dream and believe that if you give of yourself 100% to an employer and you suffer irreparable damage, that employer will stand by you through the loyal test of time, just like you did for them.
Bob Corker, tell us why Reggie Williams would.
Well, first let me say, you know, I'm here in Cincinnati. And everybody in Cincinnati has great respect for Reggie Williams. and great sympathy for the physical condition that he finds himself in today. But even under existing law, Reggie Williams is going to have a very difficult time, irrespective of Assembly Bill 1309, filing a successful workers' comp claim in California for reasons we can discuss. First, what you've emphasized, Bob, the fact that he only played a handful of games in California and otherwise had no connection
games
to the state whatsoever.
How many, Reggie?
We understand
I played
that.
20 games, and other connections I have to state is I had my very first operation in Centinela Hospital in Los Angeles. Also, when I was working for the National Football League, for you guys, I was the idea behind NFL Youth Education Town was sprouted out after Super Bowl 27 in Pasadena as a response to the Rodney King riots. I can go on about my involvement in California on behalf of the Cincinnati Bengals as a player in the National Football League, as a person that cared about kids, youth.
All right, let me bring Andrew Brandon, who's been listening very patiently. We talked about, yes, there's substance here. There is emotion. There's incredible lobbying going on in Sacramento. And, of course, each side, for and against the tightening of the so-called loophole, will, of course, emphasize the outlier cases. Give me your impressions as a man who's sat in the room when players have been cut.
You know, the thing is, Bob, we've got extremes here. You've got a situation like my old friend Reggie Williams, who's in the show here, and what's happened to him. But you mentioned the abuses, and I saw a lot of those abuses. I would just roll my eyes sometimes, Bob, as an executive with the Packers, where I would get on my desk a claim in California of a player whose only nexus to that state was maybe he played in a preseason game there, or maybe he has an agent who lives out there, or maybe he traveled there with our team even though he didn't play there or during that game. That frustrates you. And these are the type of abuses they're trying to fix with this. The question is, does it go too far? Reggie's issue and a lot of players' issues are these latent injuries that come up later, that come up way past the statute of limitations. California's trying to close those, and I think we have good minds out there between the lobbyists and between the people with the bill as how do we fix this so we don't buckshot all these players like Reggie that have legitimate claims and fix the abuses that I see so often with players just trying to get their last lick of income from very limited time in the NFL or in California. That's what we're trying to fix here. I think the bill is well-intentioned, but the question is, does it go too far with these?
Lester, please.
I'm not so sure the bill is well-intentioned. In the reporting that I've done, for every case of abuse, for every player who was there for a preseason game, there are 30 or 40 players who have legitimate injuries that occurred while they were working for their teams in the National Football League. Take the case, for example, of Junior Seau. He obviously played most of his career in San Diego. His benefits would be killed, completely eliminated, if this bill goes through as it is written. I really don't see how that is a
Bob, let me
well-intentioned
interject for a
bill
second
to have
here
a heroic
to what
player
Lester
like
just
that
said about
be
Junior
denied all of his
Seau.
benefits.
Go ahead, Bob Corker.
We've worked closely with the Assembly in the drafting of this bill. Word by word, Mr. Munson simply missed the mark. Because Junior played for a San Diego team, all right, in the state of California, this bill will not interrupt his benefits one iota.
That is not true. I've read the bill. I know the language of the bill. He has a cumulative repetitive trauma case, and it's going to end if the bill goes through.
Reggie, let me ask you this. The National Football League wanted to be very sure we were very aware of all the benefits they apply and grant to retired and injured players, and between the array of benefits from the retirement plan, from disability, from the 88 plan for neuro and cognitive problems, life improvement, Medicare supplement, long-term insurance, the numbers that they present as being part of their benefits are huge. Implicit in that is we do a lot. How much and where does the league responsibility end, if ever? What's your answer to that?
Well, it's close to a $10 billion industry that's success and popularity is predicated on fans from all ages embracing this game from very young for the rest of their lives. And so I'm not sure if you can put a time limit when the heroes who played the game for their fans collectively in pursuit of a championship. And the injuries that I have, while significant and severe, there are so many players who are worse off than me that didn't have a chance to be an executive for Walt Disney World for 14 years, and didn't have an Ivy League education, were not counseled by their teams or agents about long-term medical care and financial responsibility. So I think this is a shared effort. We have to get the NFL, the Cincinnati Bengals, each team. The National Football League Players Association also has a responsibility in the collective bargaining agreement, because at the end of the day, America doesn't want its heroes in its most popular sport limping around and frustrated at the end of their lives. This is a great game, and I'm here hopefully to encourage owners to keep making it a great game from future generations.
Reggie, you're an eloquent spokesperson, and the pictures of your disfigured knees and legs are disquieting. I mean, we've talked about this. You've been a guest on this program before. Your case is an eloquent one, and there is a reason that you're visually out there on the forefront of this issue. On the other side, the league made sure that we saw today a video produced by an outside advocacy group that kind of circles in on Marco Rivera, making him basically the poster child of what you could easily say would be, from the league side, would be abuse of the system, with $20 million in lifetime income through the NFL, projected possible $10 million in lifetime benefits from the NFL benefits. So, Bob Corker, my question to you is, who is more typical of the player in the pool here looking for benefits? Is it Reggie, or is it someone portrayed as Marco Rivera?
Reggie's not the typical case. What we're seeing from the out-of-state players...
Well, help me here. Typify the so-called typical case, and how many would you consider to be abusive filings?
The abusive filings probably exist in the range of about 90%, Bob.
90?
And I base that 90%...
No, come on.
Let me explain why before we get to the reaction. I base that 90%
Let him talk, Reg.
because, if I may finish, because more than 90% of these California claims from out-of-state players are not for the purpose of obtaining medical coverage. They are settling their medical coverage that might otherwise be available to them in California, and as a result are walking away not with medical coverage from California, but with a larger settlement. Now, if this was really about medical care, don't you think they'd be going to California and keeping their medical care? It's not about medical care.
Lester, I saw you shaking your head.
The safety net is in place for the players to have medical care both through the collective bargaining process and in the home state workers' comp jurisdictions where they played and where they worked and where they are entitled to lifetime, no deductible medical care for their workplace injuries.
Lester.
That's why the abuse, this is being used as a second and third revenue source, it's frankly double and triple dipping.
All right, Lester.
It's hard to even figure out a place to start after that polemic from the lawyer in Cincinnati. The number of players who take lump sum settlements instead of medical care are doing that for their own reasons. It's their choice to make. It's part of the legal system of California. There is absolutely no judgment to be made about those players, much less the patronizing judgment that this lawyer is making about these players. There are plenty of players in these California cases who have legitimate claims. They far outnumber those who have abusive claims. Any system like this is going to have some abuse. It happens in Social Security. It happens in Medicare. It happens in here. Believe me, the owners are well able to defend themselves against abusive claims without changing the law and without dismantling the safety net that Mr. Corker has described.
Let me bring in Andrew Brandt. Go ahead, Andrew.
Real quickly, Bob, the one thing I think people may not understand about workers' comp, if it's a factory worker or something like that, if he gets hurt, if he loses a finger, He's obviously going to get paid through workers' comp. Question is, how long does he get paid by his job? In the NFL, you can't cut a player who's hurt. So obviously, if a guy's making $1 million, he gets hurt halfway through the season, he goes on IR, we would pay him for the rest of that season, so he's still making $500,000, and then he would file for workers' comp, and then we talk about these abusive where there's triple dipping. So this is what the owners have problems with, not only double dipping, but triple dipping. And again, the question is, are there abuses, real claims? What's the percentage of each?
Andrew, when guys are cut loose, in your experience, how educated are they at that moment in what is available to them? Because one of the questions is, there's really no, the way the law currently reads in California, my understanding, not a statute of limitations. Other states, you got to file quickly. How educated are players when they leave the league as to what's available to them in this regard?
It's hard to generalize, but I know with the Packers, once they were released from the team, they were referred to the work comp attorney in Milwaukee and Wisconsin to file there. As to other avenues that they could pursue, that's where the union should come in, that's where their agent should come in. They should make them aware of all these benefit plans that the league has, now improved with the new CBA. Hopefully they're getting that information right away upon release.
Reggie?
Well, I really have to go back to the really libelous statement about 90% of the cases in California being cases of abuses. I mean, even try to bring that kind of math to a discussion says that someone has discounted fairness. Certainly, we are all committed to ensuring that only justice is being done. No one is trying to promote abuses, but there is fairness in the responsibility of a team like the Cincinnati Bengals that has made billions of dollars and will continue to make billions of dollars off of the loyalty of their fans, that the team should be just as loyal to the players that have put their body in harm's way for their behalf. And no one is asking the general public to pay our bills. All I'm looking forward to is to continue the fight that I have been fighting, that is to keep my leg, so that I can say I played the game for the love of it without putting my leg as the booby prize in the pursuit of that dream.
Bob Corker, this passed the California State Assembly 61-4. You don't have to be a political scientist to figure it out that if anything approximating this, this is going to be a walk through the state Senate. Is that pretty well anticipated from the league side that this law will become in effect and that this so-called loophole will close?
Well, you don't want to take anything for granted, Bob. There's still a lot of discussion to be had on these issues in the Senate, and I don't want to predict what that process is going to look like. But the important point here is that these issues have been discussed in California for the better part of 18 months now, almost without exception.
Why are the Cincinnati Bengals not talking to me? Why do we need a forum for the Cincinnati Bengals to do the right thing? Or any team that has had a player play for them do the right thing?
Gentlemen, I wish we had more time because we have enough emotion and facts on both sides to continue. Lester Munson, Bob Corker, Andrew Brandt, Reggie Williams. Gentlemen all, thank you. As we said, it's state Senate action time now in California. Continue the conversation at our Facebook page. Follow me on Twitter. Download our podcast. We'll be back.